Good morning. This is a discussion about the Article 17 of EU Copyright Directive in Digital Single Markets, which is a controversial directive since it has been introduced. It aims to close the value gap between the right holders and online content sharing service provider, which I would refer them as the platforms later on. In order to do so, the Article 17 is imposing strict liability on the platforms. A quick question came to my mind that whether it has struck a balance between all the stakeholders' concerns or going too far beyond. From the perspective of right holders, the platform has been earning huge profit from uploaded content, primarily from the advertising revenue. And at the same time, the platform has been holding the technology of upload filters. For example, YouTube has its own in-house uploading filters, the Content ID. And due to the previous directive did not require the platform to do general monitoring, the burden of monitoring uploading content was on the right holders. Therefore, the right holders were kind of forced to enter negotiation with platforms like YouTube to get access of Content ID in order to be able to monitor uploading content. Here, I think the platforms were holding significance of bargaining chips which have contributed to their wealth. Also, the right holders argue that YouTube should be legally required to give access to Content ID with no strings attached. Thereafter, the EU policymakers came in and implement the Article 17. In post-Article 17, the right holders seems to be the most advantaged parties, I think, and academics and Mary Birdies describe the scenario in a journal articles that the Commission takes all the boxes of music industry value gap wish list. Again, a quick question came into my mind again that how impactful is the Article 17 to the platforms? Well, from the perspective of platforms, allow me to address a few issues arising from the article itself. First, the obligations to obtain authorization by concluding the licensing agreement is imposing too much burdens on the platforms. This is because there are tons of users uploading contents online every day, and it may also have the issues of jurisdictional problems, where some of the uploaders are within EU and some of them aren't. Let's bear in mind that the internet has no parameter itself and it is boundaryless. Besides, Para 4 leaves an ambiguous word of the best efforts to the platforms to obtain authorizations, which will cause the law to be uncertain, I would say. The only answer to that, I'm afraid, is to wait for the court to decide. But the disadvantaged party is definitely would be the platforms. Second, the safeguard of startup provisions is not significant, meaningful, I would say, under the paragraph 6, where they safeguard those startups with less than 3 years and below 10 million euros, but it excludes those with more than 5 million users per year. The reason of me addressing such issue is that the internet is rapid nowadays. According to BBC, YouTube took only 2 years to reach 70 million users before. Therefore, the Article 17 ensuring the startup to have foothold in the industry, it seems to be less significant. Also, such provision also contains arbitrary protections where, in my opinion, I don't really like it. It is unfair to other platforms. Third, Para 8, which provides articles shall not lead to general monitoring obligations, is contradicting the directive itself. This is because the sub B and C under Paragraph 4 carries obligations for platforms to ensure unavailability of specific works and disable access or remove notified works respectively. Both of them require monitoring of all contents which, according to case of the SCADA extended, shall be amount to general monitoring obligations. Once again, the victim under such contradicting and uncertain directive is the platforms. 4. The obligations of the platforms having complaint and redress mechanism is practically hard to implement, as I think, with satisfaction. This is because the Residual 70 of the DSM directive requires a human's review, which ultimately will incur higher costs for the platform to bear. Once again, is an extra burden to the platforms. Well, I have been mentioning the word extra burdens. The burdens refers to costs. And the platforms are now paying more for the upload filters. In my opinion, the Article 70 might be going far beyond than its purpose, as it has hindering effect to platforms' freedom to conduct business by imposing too much burdens and too much obligations. Allow me to describe the scenario that imagine the government is trying to stop internet users from infringing right holders' copyright and to remunerate them adequately. The platform is the one who is paying the bill for what the government decides. In other words, the platform are now being punished because of the wrongdoing of the internet users. Well, the internet users are seen to be the real troublemakers, but not at all. I mean, what about the innocent one, right? From perspective of internet users, the upload filters requirements is also infringing the fundamental human rights which are enshrined under the Charter Fundamentals of Human Rights. The CJEU in the case of Pro Musica stressed that member states shall be striking balance between human rights and intellectual property rights. To go deeper, the upload filters affect the internet users' freedom of expressions and informations due to the platform's notice and stay out obligations. Upload filters like content ID and audible magic is reliance on limited informations are consequently subject to errors. Accumulations of such error might cause false positive and false negative. On the other hand, in order to resolve such matters, Para 9 requires platform to have an appeal channels. However, in my opinions, the so-called appeal mechanism is potentially infringing internet user freedom to fair trial, as the blocking, appealing, and unblocking they are of same entity, and internet users will not likely to have any further appeal pathway to seek for. Last but not least, the upload filter is also infringing the right to respect for private and family life and protections personal data. Sounds serious, right? This is because the mechanism of the filter itself is scan both content and context being uploaded. The process of it actually is carrying the risk of leaking users' personal data, I would say. Academic Simon Brown suggested for implementing a content-only filters like YouTube's content IDs. However, such lower standard filterings may against the best effort standard, remember, under the Para 4. Therefore, higher standard of filtering will cause infringement of human rights, while lower standard of filterings might not achieving the aims of the directive. At this point, it is evident that the Article 70's upload filter is not striking the balance between the right holders' copyright protections and the human rights of the internet users. In conclusions, the upload filter is not striking the balance. Academic opinion like Brady and Sokumaran suggested that the upload filter is favoring one party over the others, which is the right holders, I would say. Notwithstanding of the academics' opinions, I only partially agree on the statement, as I foresee that in the long run, the upload filter service provider is potentially being favored over the other stakeholders. The filter service provider will be the one holding bargaining chips, as upload filter is now a requirement to the platforms. Big tech companies like Audible Magic might monopolize the whole digital market eventually. At the end, the right holders are still not being remunerated adequately, as the allocation of revenue from platforms will contribute to the filter service provider in order to comply with Article 17. All in all, no balance has been struck and the directive will not serve its initial purpose. Thank you very much.